Hello, everybody. On the record in the matter of the state of Michigan versus Rayshawn Worthy, 25-02387. Appearance, please.
Assistant Public Defender Joseph Hardy on behalf of Mr. Worthy, who is walking in and appearing via Zoom. Thank you.
Okay, you're Rayshawn Worthy.
Yes, Your Honor.
Okay, Mr. Worthy, I have a felony complaint here. The allegations are that on or about August 5th, 2025, saying that you committed the act in count 1 of assault with intent to do great bodily harm, less than murder or by strangulation, and that you did make an assault upon a Desiree Terry Lynn Allen Marion by strangulation or suffocation, and that this was contrary to MTL 750.84. Count 1 is a felony with a maximum penalty of 10 years in prison or $5,000 in fines. Your DNA is to be taken upon arrest, and a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. Count 2, domestic violence, alleges that on or about the same date and time at the same location that you did make an assault or assault and battery upon Desiree Terry Lynn Allen Marion, an individual with whom you had a dating relationship, and that this was done contrary to MTL 750.812. That's a misdemeanor. The maximum penalty is 93 days in jail and or $500 in fines. Again, a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. You are, however, charged as an habitual offender, 4th offense notice. It says, take notice that the defendant was previously convicted of 3 or more felonies or attempts to commit felonies, and that on or about September 11, 2018, he was convicted of the offense of tampering with an electronic communication device in violation of MTL 771.3F in the 4th Circuit for Jackson County in the state of Michigan. And that on or about January 15, 2019, he was convicted of the offense of assaulting, resisting, or obstructing the police in violation of MTL 750.81D1 in the 4th Circuit Court for Jackson County, state of Michigan. And that on or about January 15, 2019, he was also convicted again of assaulting, resisting, or obstructing a police officer in the 4th Circuit Court for Jackson County. Therefore, the defendant is subject to the maximum penalty of life in prison if the primary offense has a penalty of 5 years or more. Your primary offense does have a maximum penalty of 5 years or more. You are facing a maximum penalty in life in prison at this time. Do you understand that?
Yes, Your Honor.
You have the right to be represented by an attorney. Mr. Hardy is representing you for your arraignment only, but you do have the right to have an attorney represent you at all of your court dates and if you are going to be questioned by law enforcement. If you can't afford to hire an attorney, you can make a request to have the public defender's office appointed at no expense to you. Do you understand that?
Your Honor.
You have the right to remain silent. Anything you say, anything you put in writing can be used against you. You can plead guilty, plead not guilty, or stand mute. If you stand mute, the matter will go all the way to a trial. You are being charged with a felony, so you have the right in count 1 to have a preliminary examination within 21 days of today's date. You have the right to have that within 21 days unless you waive that timeline or the court finds it a cause to go beyond the 21 days. You have the right to require the prosecutor at the time of your preliminary examination to establish that they have sufficient probable cause that the felony you're being charged with was committed and a sufficient probable cause to charge you with a felony, okay?
Yes, Your Honor.
You're currently scheduled for probable cause conference before me, Judge Kristen Simmons. It's going to be on August 15th at 9:30. You have a preliminary examination before me in person at the court, August 22nd at 9:30. You should have received a notice to appear. Can you confirm?
Yes, I did, Your Honor. I received it.
Okay. You have the right in this matter again to proceed to trial and to maintain your presumption of innocence. So you're innocent until proven guilty. You have the right to maintain that innocence and have the prosecutor prove each element of each of the charges beyond a reasonable doubt. You have the right to maintain silence at any trial and not have silence be used against you, or you can waive silence and testify at your trial. You have the right to subpoena witnesses to testify for you at trial, and the right to see, hear, and question any witness that's called to testify against you. Do you have any questions about any of those rights?
No, Your Honor.
Are you currently employed?
Yes, Your Honor.
Where?
I work for Roxy Cafe. It's a restaurant in Jackson, Michigan. On Ganson.
What's it called?
Roxy Cafe.
Roxy Cafe. What's your phone number? Are you on probation or on parole?
No, Your Honor.
Do you have any other criminal matters pending?
PPO violation, that's it. It's out of 30th Circuit Court. They just PR bond me for it today.
You have a PPO in 30th Circuit?
Yeah, I just was arraigned on it today because of the
Okay,
charges that right now.
Is the protected party is Desiree?
Yes, Your Honor.
Is he requesting the public defender to represent him?
He is, Your Honor, and I was able to speak with him and complete an intake.
Okay, the court wants your plea of not guilty on your behalf. Let's see. You can address bond.
Thank you, Your Honor. So, what we do acknowledge the previous habituals that you kindly listed off. I would just say that the most recent pair being the felony RNOs in 2019. I would say that none of those previous felony convictions involved any type of acts of domestic violence against this partner or against anyone else. So I would say that these somewhat dated, but at least by 6 years, offenses are not indicative of any type of future danger or harm to society. He does admit to at one time failing to appear because he forgot his court date, but he represented to me that this was a case of him simply forgetting his court date, and he addressed it as soon as he did without having to get picked up for it. He's lived in Ingham County for at least two and a half years, and Michigan his entire life. And as he's previously stated, he does work at Roxy Cafe, and all these any type of concern that the courts may have regarding harm to society, I think could be alleviated by the use of a GPS tether. So with this, I'll just be requesting a PR bond.
Maybe I'm missing something. He has a PPO with the same victim. So that right there is a presumption that at least the circuit court believes that there was enough grounds to grant a protective order for this person that allegedly he was with in violation of this PPO with yesterday and allegedly committed a domestic violence and an assault with intent to do great bodily harm less than murder and is facing life. I looked at his prior criminal history. He has over 15 prior charges of assaultive actions. 15 times he's been charged with something assaultive. He's a threat to the public safety. Bond in this matter is set at $50,000 cash surety with a GPS tether. There's a no contact order. You're not to have contact directly or indirectly with the protected party, that being the Desiree Terry Lynn Allen Marion. You can't call her. You can't text her. You can't call her from the jail. You can't have anybody else call her on your behalf while you're in the jail. You can't be within 2,000 feet of wherever she is for whatever reason. Do you understand that?
Yes, Your Honor.
Do you have any questions, comments, or concerns or confusion about a no contact order?
As far as the PPO, I think that they only
I'm not talking about your PPO.
violated my.
I'm not talking about you. I'm not talking about your
know.
PPO. Do you have any questions, comments, or confusions about the no contact order that I
No,
just
Your Honor.
issued?
No, Your Honor.
While out on bond, you're to wear GPS tether. There'll be victim notification if possible. You're not to possess a firearm, ammunition, or weapon of any kind. You must report to pretrial services within 48 hours of your release. You're not to use alcohol or drugs without a prescription. You're not to travel outside the state without prior approval of the court. You need to be at all your future court dates. You'll see me on the 15th. You have any questions?
No, Your Honor.
Any additional matters for the record?
No, Your Honor.
You're all set. On the record, in the matter of the state of Michigan versus Ron Archer, 25-021323, that is, council appearance.
Thank you, Your Honor. Assistant Public Defender Joseph Hardy on behalf of Mr. Archer.
Okay, Mr. Archer, I have a misdemeanor complaint alleging that on or about June 14, 2025 at 3916 Stabler, Lansing, Michigan, Ingham County, that you made an assault or assault and battery on a Yasmin Bonet Orta on or about June 14th, a resident or former resident of your household, or a person in which you have a child in common, or an individual with whom you have a dating relationship. Count one is a misdemeanor, maximum penalty, 93 days in jail with $500 in fines. Consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. You understand the charge and the penalty, sir?
Yes.
You have the right to counsel. If you can't afford to hire an attorney, one can be appointed to represent you at the expense of the public. You have the right to remain silent. Anything you say and anything you put in writing can be used against you. You can plead guilty, plead not guilty, or stand mute. If you stand mute, the matter is going to go all the way to a jury trial. You are presumed innocent until proven guilty. You have the right to require the prosecutor prove your guilt by proving each element of the charge of domestic violence beyond a reasonable doubt. You have the right to see, hear, and question any witness in court that's called to testify against you. The right to call your own witnesses or present evidence that you believe show defense to the charge being brought against you. The right to be silent and not have silence be used against you, or you can waive silence and testify at your trial if you'd like. You're currently scheduled for a pretrial conference on August 26th at 9:30 before Judge Tony Flores. Did you get a notice to appear?
Yes.
Okay. Counsel, is he requesting the public defender to represent him?
Yes, Your Honor.
The court is entering a not guilty plea on your behalf. What's your home address?
52.
Or what street? Are you staying with someone? Is that why you're giving me that address?
No, I've been renting that house for years now.
Your bills.
I just got laid off from Ryder.
Pay your bills. Employed?
No, ma'am.
How do you pay your bills?
I just got laid off from Ryder. I gotta do a few things to get back in.
What's your phone number?
517-420-7193.
Are you on probation?
No,
Are you on parole?
no,
Do you have any other pending matters?
yes,
Have you ever missed court in the past?
no,
Are you in bench warrant status right now?
what's that?
My records indicate you have a bench warrant out of the 56th District Court.
No, is that Eaton County?
It's Eaton County. Operating
no, I
while
took care of-
intoxicated. Bench warrant.
I took care of that already.
So that means you've missed court before. Correct,
Yes,
correct?
yes,
Which was the last question I just asked you that you said no, correct?
right, correct.
You can address bond counsel.
Thank you, Your Honor. Mr. Archer is someone who's stated to me that he's lived in Lansing his entire life. That while he is on bond out of Eaton County for the OWI, he stated that he's not someone that possesses a criminal record, violent or otherwise. We do acknowledge the previous bench warrant for Eaton County, the Eaton County case. However, I would say that that's not necessarily entirely indicative that he's looking to flee this court's jurisdiction or not show up here. And also with the charge, I would just be requesting a PR bond.
He told you he didn't have any prior criminal record?
Correct, Your Honor.
He lied.
Well, that wasn't the truth. I'm looking at his prior criminal record. He also has a pending OWI. That's how I knew that he had a bench warrant. I knew these answers before I asked him if he ever missed court, and he opened his mouth and told me no, he never missed court. He has convictions for operating under the use of controlled substance. And another conviction that was deferred. So I don't know why he told you he didn't have any prior convictions. He also has been charged with other matters that did not result in conviction. So I don't know why he would relay that information. I don't know why he would say to me that he's never missed court before when he is listed as of today in bench warrant status, other than he's not honest. So I have a concern about that, but nonetheless, bond in this matter, because this is a matter that typically is released on recognizance. I will grant the personal recognizance bond, but you are going to be released with GPS tether.
Okay,
Bond is $500 personal recognizance with GPS tether. You're not to have contact directly or indirectly with the protected party in this matter. Yasmin Orta, do you understand that?
yes,
Not to be within 2,000 feet of wherever she lives, works, or goes to school. No contact directly or through third party. You can't have anybody else call on your behalf. You can't text. No communication of any kind. You're not to travel outside the state without prior approval of the court. You're not to use a firearm or possess a weapon of any kind. You're not to use alcohol or drugs unless you have a valid prescription. Do you have any questions?
no, ma'am.
Any additional matters for the record, counsel?
No, Your Honor.
You're all set.
Be safe, be well, sleep sweet, and much love.